Continue case item 4, second appeal 209 of 2018.
कौन-कौन से exhibits आपके लिए important?
For exhibit 1A and exhibit F.
Exhibit 1 by A में plot number कितना है? 1 by A में plot number?
3846.
नहीं
खाता नंबर
खाती नंबर का ही
खाता ही
मतलब
नंबर का डिस्प्यूट है
खाता नंबर
121.
नोट एग्जिबिट 1 बाय ए नोट लॉर्डशिप का रिकॉर्ड में लिखा है नोट हम फ्लैग लगाए लेकिन एग्जिबिट एफ
बाद में पहले
नहीं,
their
हम
entire
बोले-
case is based on exhibit 1 by
1
A.
बाय ए
Exhibit 1 by A में आप ही बताइए ना खाता नंबर
बट उसमें खाता 1 2 और उसके बाद 1 और 2 जो है उसको बहुत हाथ से लिखा हुआ है इसलिए ये नहीं बोल रहे क्या कीवर्ड 121 है या 122 नोट वो प्लास्टिक वाला फ्लैग लगा हुआ है साइड दैट इज 1 बाय
जो बोल किया हुआ
हां एंड नाउ योर लॉर्डशिप
फोर्जरी का कोई एलिगेशन है
नहीं,
फोर्जरी का कोई एलिगेशन
इवन रिटन स्टेटमेंट में आप पढ़ देंगे जो
Forgery का
केस
कोई
यहाँ पे
allegation-
काउंट कर रहा है और
एक सेकंड
रिटन स्टेटमेंट नहीं था.
एक सेकंड
फोर्जरी का कोई एलिगेशन नहीं है लेकिन नॉट इन द अपीलेट कोर्ट बट वी हैव
दिस इज खाता नंबर 120 नहीं समझ आ रहा
तो वही बोल रहा नहीं समझ में आ रहा
120
क्योंकि नॉट 1 भी हो सकता है और 2 भी हो सकता है रीड के अंदर अब इसका सर्टिफाइड कॉपी लोअर अपीलेट कोर्ट में और इसको मार्क हुआ एग्जिबिट एफ दैट नोट्स वी बोथ हैव सीन वहां पे है नहीं
क्या नहीं
मतलब
1 by
exhibit
F
F
जो है
नहीं नहीं एग्जिबिट एफ
हाँ, 1 by
वन
F, sorry, sorry.
एफ नो
Yes.
दैट डॉक्यूमेंट
हाँ
एग्जिबिट एफ जो मार्क हुआ लोअर अपीलेट कोर्ट में दैट डॉक्यूमेंट इज नॉट
हम लोग देखे दोनों
नहीं है
नहीं
हम लोग दोनों देखे हैं.
क्योंकि वो अपीलेट कोर्ट में लगता है
हम
मार्क
दोनों
हुआ
मिलान कर रहे
ऑल्दो
हैं.
नॉट एग्जिबिट पे तो होना चाहिए था लेकिन है
In fact, note order 41 rule 27 petition was allowed by the appellate court by order dated 18/2/2018.
आपको दिखवाना है
हाँ,
17
17/2/18. That order sheet is there.
लेकिन एग्जिबिट नहीं
Exhibit F.
That document is not available on the photocopies.
सिर्फ एग्जिबिट एफ ही आया था कि उसके अलावा भी कुछ आया था
बाकी सब तो
नहीं
है.
खाली एग्जिबिट एफ ही मार्क हुआ
क्योंकि एग्जिबिट 1 to 1 by एग्जिबिट A to E मार्क हो चुका था ट्रायल कोर्ट में.
ठीक
ये appellate कोर्ट में हुआ है F by order dated 17/2/2018.
देखिए The learned counsel for the parties have jointly submitted that Exhibit F, which is certified copy of
certified copy of deed notes mention certified copy of
That
sale
I am
deed number
disputing.
45
Getting some.
dated 10/1/47
certified copy of
sale deed number 45 dated
sale deed number 45 dated
10/1/1947
10/1/1947, which is the certified copy of Exhibit 1 by A.
1 by A
Exhibit 1 by A is dated 3rd
वही
January
तो कैसे आप बोल
1947.
रहे हैं?
हम
3rd
That is
January
3/1/1947.
1947.
लोअर अपीलेट
Yes.
कोर्ट नोट हम दिखा रहे जो एग्जिबिट एफ जो लॉर्डशिप
वही तो हमारा
जिसमें ये
dispute है.
मार्क हुआ है
ट्रायल में इसलिए
अच्छा
नहीं आया.
Exhibit F आने दीजिए।
हां एफ
आने दीजिए
3147 है इसमें
एक
नोट
सेकंड
सिग्नेचर का डेट
वो हम लोग वो नहीं लिखेंगे
हाँ.
The learned counsel for the appellant has submitted that Exhibit F was produced by the defendants before the first appellate court, which was certified copy of sale deed number 45 dated 10/1/1947, wherein the khata number was mentioned as 122,
Yes.
but the records as received from the court concerned does not contain Exhibit F, though it was placed on record by way of additional evidence and has also been referred to in the final judgment passed by the learned first appellate court. Counsel for the respondent has submitted that the plaintiff was claiming property by virtue of say lead number 3,
Actually, it's deed of settlement.
deed of settlement,
वो
registered
सेल्डी-
deed,
दोनों को गलती
हाँ,
लिखा है।
registered.
Registered deed of
Registered.
settlement.
registered deed of settlement dated
Dated 3/1/1947.
3/1/1947,
Exhibit 1 by A.
Exhibit 1 by A, which has nothing to do with Exhibit F. However, since Exhibit F is not on record, office is directed to call for a photocopy of Exhibit F from the learned first appellate court. उतना में हो जाएगा?
जी।
Let this order be communicated through fax. Special messenger cost जमा कराइए तो अभी मंगा लें। थोड़ा सा तो लगता है 100 रुपए लगता है। Upon deposit of special messenger cost by the appellant, which is to be deposited within a period of 1 week. Post this case for further hearing on thirtieth April. To be taken up as first case at 10:30. छोटा सा तो मैटर है।
वही दो डॉक्यूमेंट है।
उसके साथ साथ सराउंडिंग फैक्ट्स भी तो बोलना।
हाँ।
ये मत बोलिए कि दोनों डॉक्यूमेंट।
जो क्वेश्चन ऑफ लॉ ये बनवाए हैं सर, उसके अलावा कुछ हमको सुनने का जरूरत ही नहीं है। अगर आपका एग्जिबिट 1 by A
क्वेश्चन ऑफ लॉ में ही करेंगे, क्योंकि उसमें तो हमारा कोई अपॉर्चुनिटी नहीं। अब हम एक्सप्लेन करेंगे वो तो गलती से दोनों कोड बोल दिया सेल्ड, एक्चुअली सेल्ड डीड नहीं,
सेटलमेंट
रजिस्टर्ड डीड ऑफ सेटलमेंट है। तो हुजूर भी इसीलिए सेल्ड डीड लिख दिए, क्योंकि दोनों कोड में वही
दोनों
लिखा है।
कोर्ट में लिखा हुआ है
तो आने दीजिए।
अब दूसरा बात है कि प्लीडिंग भी लिखी।
रिटन स्टेटमेंट में कहीं नहीं है कि 122।
Yes, plus evidence beyond pleading and pleading without evidence.
सर हम भी सेम वही पॉइंट बात कर रहे हैं
बस
कि प्लेंटिव को अपना केस अपने शुरू करना है, इनका अपना
हम
प्लीडिंग है नहीं कि जो
अपना
बेसिक
चुके हैं।
बेसिक डॉक्यूमेंट
दोनों कोर्ट में हम
122 के
साक्षी किए
ये सब नहीं होगा तो आप दोनों
हाँ।
और हम क्या करेंगे? यही सब करना। चलिए।
Fifth case item 8, first appeal 77 of 1923, along that 9 and 10.
Are you there?
Srivastava is also here, I guess. You have already submitted the notes and argument.
आपका ये नोट्स ऑफ आर्गुमेंट से हमारा आपका आर्गुमेंट खत्म नहीं होता है ना? Can't be like this. You have to argue your case full fledged.
Yes, that.
पूरा argue.
That will-
First appeal है ना?
Yes, sir, that we
बहस
will do.
करना
That we will do, yes.
पड़ेगा।
To begin with.
Record this. आपका रिटन नोट्स ऑफ आर्गुमेंट है अदर साइड का
Oh, they are given. हमें रिसीव कराया था बस.
on behalf of the appellant अदर साइड का
In two cases, we are the appellant.
We are the
Third case.
आपका कोई ओपोनेंट है कि नहीं है?
हाँ,
तो ओपोनेंट ने भी कोई रिटन सबमिशन फाइल किया है क्या?
उन्होंने 156 में फाइल किया।
बस एक ही में फाइल
एक
करें
ही
दूसरे में उनको कोई मतलब नहीं दूसरे केस से?
नहीं,
कैसे बोल रहे हैं? नहीं मतलब वही बताएंगे ना कोई मतलब नहीं है तो लिखेंगे that they are not contesting these two cases.
yes, that's correct. He has
You
to
like?
say this, we are not.
That they are not contesting these two cases.
Correct.
बस उसके बाद फिर क्या? Then we have a case. कहाँ है अदर साइड?
One side is.
आपने तीनों केस का एक ही रिटन सबमिशन बनाया है?
दो का हमने बनाया है और तीसरे में जरूरत नहीं है क्योंकि ऑलमोस्ट दैट इज अ काइंड ऑफ एडमिटेड पोजीशन, मतलब जो हमने कंटेस्ट किया वो एडमिट कर रहे हैं।
You have filed in first appeal number 77.
Yes, and also
And
first appeal number 44, both filed by me, and because his notes and arguments are practically supporting my case, so I have decided not to necessarily
They are not appearing. आपका केस है?
सीरियल 8 में क्यों?
हम से पूछेंगे कौन सा सीरियल नंबर
Sorry,
है,
sorry,
बाकी
sorry.
केस नंबर और फैक्ट हम ही बताएं।
नहीं रुजू बने मुझसे आपने तो ऑफिस में फाइनल आर्गुमेंट हो गया था और आर्गुमेंट का ऑफिस
सुनिए, आपकी तरह स्पीड में हम नहीं सोचते हैं। अब आपका केस है, आपको पूरा बहस करना होगा। फर्स्ट अपील है ना, प्लेन रिटन स्टेटमेंट प्लेस किए हैं आप लोग?
हाँ, रिटन आर्गुमेंट फाइल हो चुका है।
उससे क्या करें हम रिटन आर्गुमेंट का?
तो एक्चुअल प्रॉब्लम में जो बहस किए थे ना उसकी बात का सीरियस हो गया, लेक्चर में बाहर तो हम बहस नहीं किए थे।
बहुत अच्छी बात है, फिर आपको एडजमेंट चाहिए। और ये जो आप बोल रहे हैं रिटन आर्गुमेंट फाइल हो गया है, हाँ, तो यही लिखा देंगे, दोनों आर्मी रिटन आर्गुमेंट फाइल किए हैं, दे हैव रिफ्यूज्ड टू आर्ग्यू इन द
नहीं रिफ्यूज क्या करेगा?
फिर
माने जो प्रॉब्लम
फर्स्ट अपील ऐसे डिसाइड होता है जी।
नहीं, जो जानकारी हुजूर को दी है
हाँ, वो तो ऑर्डर एडजमेंट ऑर्डर में ही लिखा रहता है मेरा, आपको कोई जानकारी देने की जरूरत नहीं।
अच्छा, तो हमको हुजूर, मेरा ड्यूटी बनता है कि आप हुजूर को जानकारी दें।
तो कब आएंगे वो बहस करने? और आपने क्या सारे केसेस में रिटन नोट्स फाइल किए हैं?
तो
या वो भी जानकारी आपको
नहीं वो वाला दिया है जो फर्स्ट अपील हम फाइल किए उसमें दिया।
दिखाइए सर।
तीसरा नंबर पर 156
प्लेंटिफ रेस्पोंडेंट 156
हाँ उसमें फाइल
और इसमें अपीलेंट कौन है?
ये
156 आपने फाइल नहीं किया है।
156 रिस्पोंडेंट उसमें जरूरत नहीं है बिकॉज़ दैट इज एन एडमिटेड व्हाट आई हैव
ये तो बोल रहे हैं humble written notes of argument on behalf of plaintiffs respondents।
तीसरा में हम प्लेंटिफ है हुजूर।
156 की बात कर रहे
हाँ
हैं।
उसमें हम प्लेंटिफ,
आई एम द रिस्पोंडेंट
अपीलेंट कौन है?
हम ही हैं।
तो प्लेंटिफ रेस्पोंडेंट लिखे हैं तो अपीलेंट कहीं लिखे नहीं है तो हम क्या समझेंगे? ये आपका है,
जी 156 बनता है।
इसमें आपको नहीं फाइल करना कोई जरूरत नहीं। और बाकी दोनों केस में आपको नहीं फाइल करना है।
तो हम रिस्पोंडेंट हैं।
तो रिस्पोंडेंट को रिटन सबमिशंस नहीं फाइल करना, बहस करेंगे ना? तो फिर आप ऐसे कैसे बहस करेंगे? आप अपना रिटन सबमिशंस फाइल करेंगे, इस तरह से नहीं।
ठीक ठीक
कौन बहस करेंगे आपकी तरफ
संजय
से?
कुमार सिन्हा वही किए थे।
फर्स्ट अपील नंबर 77 of 2023 and other analogous cases. Learned counsel for the parties are present. Counsel for the appellant in first appeal number 77 of 23 and first appeal number 44 of 23 has submitted that they have filed a common synopsis of argument, written notes of argument in these two cases. And so far as first appeal number 156 of 2023 is concerned, they are the respondent and they do not wish to file any written notes of argument. And they submit that this is so in view of the written notes of argument filed by the appellant in first appeal number 156 of 2023. Learned counsel for the respondents in first appeal number 77 of 2023 and first appeal number 44 of 2023, who is the appellant in first appeal number 156 of 2023, has submitted that written notes of arguments have been filed only in first appeal number 156 of 23. And so far as the other two cases are concerned, he prays for some more time. The learned counsel has also submitted that the arguing counsel is out of station on account of some personal difficulty. He submits that the matter be posted on the pen. Date,
नेक्स्ट
आपसे पूछ रहे हैं date,
हमसे नेक्स्ट वीक कोई डेट,
हाँ?
नेक्स्ट वीक कोई डेट दीजिए।
आज Tuesday है,
जी
आई मंडे
अच्छा हाँ आज Monday है सर।
छुट्टी है मंडे को बंद है।
हाँ क्योंकि वन भी है शायद।
तो फ्राइडे
फ्राइडे हम लोग का टाइगर मैटर है, फ्राइडे में
सेकंड बार
just a moment, I'll give you a date. Please hold on. April. In the meantime, the written notes of argument should be filed on behalf of the respondents in FA number 77 of 23 and 44 of 23, latest by 22nd of April. आप तो अगला हफ्ता मांग रहे थे, आपको तो टाइम मिल गया 22 अप्रैल तक फाइल
ठीक
इसका लेकिन उनको फाइल में डिस्कस निकालिए और एक साथ मांगेंगे।
Auto and mention के item 55, 2nd April 280 of 2023.
Record.
Very short point is involved. Direct, the legitimacy in the order of admission dated on 10/2014, order number 5. That is the only point,
Can you read
probably this would be shortest.
Can you read it?
May I read the question?
Yes.
Whether in view of the specific pleading of the defendant in written statement that the description of the suit land is vague without any boundary, trace map and other description, even though without any doubt the same is part plot, and in absence of description sufficient to identify the suit plot, no degree as sought for can be passed, and therefore both the courts below have committed perversity by failing to consider the same and not framing any issue or point for determination respectively. So your Lordship may see the brief fact of the.
Is there any dispute regarding identity of the property?
Yes,
Boundary.
boundary. Admitted case, I'll first state, admitted case that the plaintiff herein was the owner of the property. This is not in dispute. We cannot dispute because
Okay. Yes.
now he had transferred out of the total area which was purchased by him. In para 4, if your Lordship would take up the plaintiffs, or the impugned government also the fact
You
of
will see from
inserted.
the plaint only because we are referring to plaint and written statement.
Yes. There are 4 of the plaintiffs. In these 2 paragraphs itself, entire case is written.
Plaint, right.
Paragraph 4. Further, it is to be mentioned that father of the plaintiff, when he was in need of money, sold a portion of the land at Moja so and so, yes so and so. In Khata number 86, this may be mentioned. Taken note of. Khata number 86, plot number 645/A, Goda 3, area 5 decimals. To the defendant number 1. This was sold to me, 5 decimals was sold to me, and by registered deed number dated 16/12/1987. So this is also not in dispute. The plaintiff himself says that by this deed of 16/12/1987, an area of 5 decimal was transferred to me.
Boundary is also given.
Yes, yes. Boundary agreement. Then, in the next paragraph, what was sold to me has been mentioned. It has been mentioned that what was sold to me. Then he says that subsequently I have encroached 2.5 decimal of land. This is the entire case. And then other statements have been made.
You have encroached 2.5 decimal of land over and above.
That is what they intend to say. And Your Lordship may see the schedule. In the district Saraikela, Kharsana, Thana, so and so, being Khata number 86, lot number 645A, Kisenbi, area 2.5 decimal, no, absolutely no. So difficulty would be ultimately. This is squarely covered by one recent judgment of Honorable Supreme Court in Rahul Lessa, where Your Lordship, I'll just place that judgment, and that is the only point.
So at the how will this is a non-executable.
Therefore, Your Lordship, therefore, this is the exactly over.
Yes, please.
So they should have said it. Now the problem is, Your Lordship may see the relevant portion which affects us, para 30, 31.
Yes.
As the trial continues between specific parties before the court and is based on available pleading, sometimes vague description of property raise genuine or frivolous third party issues before delivery of possession during the execution. And then, para 35. We are of the opinion, after 2 lines, we are of the opinion to avoid controversies and multiple issues of the very vexed question emanating from the rights claimed by the third party. The court must play an active role in deciding such related issues, subject matter during adjudication of the suit itself, and ensure that a clear and unambiguous and executable decree is passed in any suit. And then relevant para 42. The court says that if all courts dealing with the suits and execution proceedings shall mandatorily follow the mentioned directions, and 42.5 is the relevant enactments. The court must, before passing the decree pertaining to delivery or possession of a property, ensure that the decree is unambiguous so as to not only contain a clear description of the property but also having regard to the status of it. So this is the mandatorily that has to be put. And if it was not there, then the court could not have passed a decree which is inexecutable. Ultimately, multiple issues would arise before the execution. So both the courts have failed to perform their part of the, and therefore consequently it is perverse. Because this was raised in our defense, in our written statement. That the suit property is vague.
What was the total area of the property which was purchased?
Purchased by
Total
the
area.
plaintiff.
Yes, total
Yes,
area.
it was. That
It
has
was only
not,
a portion.
Your
What was the
Lordship,
total
that has
area?
not been mentioned in the plaint, but it has ultimately come in that it is mentioned in the judgment.
Let us read the judgment.
Yes.
What is the total area?
Yes. I had read somewhere that it was 20 this year. But
25 days.
What was the description? Total area? the plaintiff has adduced the original sale deed at page number, internal page 12 of suit. The plaintiff during course of evidence has adduced the original sale deed number 2247. This is the one.
That is executed document.
Yes.
Original.
Exhibit 4.
That, Your Lordship, we cannot dispute that he had a larger property. Your Lordship is referring to page
12.
12. The plaintiff during course of evidence has adduced original sale deed so and so. Present deed is bilateral document relied by both the parties which is not in dispute is also filed on behalf of the defendant as per contents of the so and so. The same has been executed by Baiputnath Kavi, son of so and so, in favor of Puran Chandra Mishra of the land at Chota Gamaria, so and so, recent khata number 86, plot number 385, recent plot number so and so, 20 decimals of land with specific boundary in Bara Gamaria. The nature of the land is so and so. Therefore, Your Lordship, it was 20 decimal.
It was 20
And-
decimal.
And
So this was 20 decimal as per exhibit 4 dated 1962.
Yeah.
And this property was sold in 1987.
by the purchaser.
By
That
the
means
purchaser.
plaintiffs.
Okay.
Plaintiffs have purchased this property and
Where is the mention about this property? What was this exhibit? 16,
Exhibit
12,
4 and
86.
exhibit B.
Exhibit 4 is 1962 document. Where is the document safely dated 16/12/87
it is there.
on the basis of which the plaintiff is claiming?
Exhibit B also and it was exhibit B on our behalf and exhibit 2. Exhibit 2 and exhibit 3.
Related to khata number 86. Khata number 86, Thana number 57, area 25 decimal.
No, it would be 5 decimal.
What is the description of property in this?
In the sale deed. Yes.
It is on page 6, internal page 6, schedule.
The deed is by Sri Puran Chandra Mishra in favor of Srimati Ganga Rani.
The boundary of your property is identifiable.
My property. Yes.
That is clearly identifiable.
Yes, it has been mentioned.
So in order to execute the decree, your area will be
My property
identified.
would not be seen.
Why will
The
not be
court,
seen?
the problem would be that
Your
which-
property is already demarcated. Your property is already identified. your property has a definite boundary. So your property will be identified and rest you leave it. How do you say it is a non-executable?
Because which portion I have encroached upon, even
See,
if,
you are concerned only with your property.
second,
If you are found in
because-
possession of
because
any
second
portion of
line
land.
was that, which was difficult line, it was said that we had, on the date when this sale deed was executed, we had entered into an agreement, and by a separate agreement, the 2 decimals of land the plaintiff had transferred. This was, and that was marked as exhibit D. But your lordship, here the question is only with regard to the question of law that has been formulated.
So therefore, how
That
do you
is
say that this decree is not executed?
Because the court would not, now, the executing court would not see my deed. The executing court has to be concerned only with regard to the decree which have been, the property which have been mentioned in the
The
decree.
executing court will see the judgment and say that your property, right? Your property you are claiming by virtue of a registered sale deed,
Absolutely.
which has a particular bound. So that will be demarcated simply. Unless you are claiming.
No, according to me.
And this property.
Because your lordship, what would happen that the decree is there before the court, which is to be executed, and that specifically mentioned the bound.
Even if a person is a plaintiff or a defendant, has also got right to file certain objections at the stage of execution.
Now, can the executing court perform a duty or conduct a trial which the original side it was required to do? Executing court has to execute the decree as it is. It cannot supplement or anything. It has to execute. If your lordship feels that it is executable, then
I will be permitted to make a short submission.
Just.
that is all, your lordship. This is
What is the written statement?
written statement. Yes. This specific question I can read the whole, but your lordship will only allow me to place the relevant.
Only the.
Para 6, your lordship, where I have mentioned that the description of the suit land is totally vague without any boundary, trace map, and other description in absence of which no decree as sought for can be passed.
Yes, what do you have to say?
Yes, you will see the print he was reading. Para 5 and 6. Para 4. Description is already mentioned in this.
Read para 4 once again.
Para 4 of the
नहीं पहले से पढ़िए.
plaint.
1, 2 भी पढ़िए.
1, 2. Subject matter of the suit is the Rayati plot situated in Mauda, Chota, Gamaria, PO, Grand Substance within Khata.
ये सच मत पढ़ा के ये
जी.
तो समझ नहीं आता. आप ठीक से पढ़िए इसको.
PO and PS Gamaria, district Saraikela, Kharsa. Within Khata number 86, plot number 645 A, Don 3, area 2.5 decimal, within the jurisdiction of your Honor's Court, and the Schedule A of the grant shall be recorded herein as the suit land. The above plaintiff has filed the suit for demolition of illegal and unauthorized construction made by the defendants above number 1 and 2 over the scheduled property of the plaintiff, and permanent injunction restraining the defendants above from interfering with the plaintiff user of the land in dispute. The plaintiff is the Rayat as well as the bona fide owner of the scheduled land by way of registered deed of sale 2290 dated 18/9/1962, duly mutated in favor of the plaintiff's father, and thereafter the plaintiff's father came in possession of the suit land on payment of rent to the government. That further, it is to be mentioned here that father of the plaintiff, when he was in need of money, sold a portion of the land situated at Mauza Chota Gamaria, PO and PS Gamaria, Thana 67, in billing khata number 86, plot number 645, A, Goda 3, area 0.05 decimal corresponding to old khata number 18, old plot number 385, A, bounded on north Simana Bada Gamaria, Samshan Ghat, south Niz, east Parti Khas, west Niz of the defendant. Number Ganga Rani White registered city 3549 dated 16 December 1987 and after sale delivery of possession of an area of 0.05 decimal were given to the above defendant verified that as a matter of fact the father of the plaintiff became old suffering from different disease even not able to look after the household affairs requires demarcation of their paternal property. It has come to the knowledge of the plaintiff that demarcation was held on the spot by Anchalamin Kamaria Anchal on 24 December 2014. And after obtaining the certified copy of the Anchalamin report, it was found that an area of 0.02 and a half decimal has been enclosed by the defendant number 1 and 2 above having constructed building line therein for commercial purpose. This is exhibit 3, certified copy of this Anchalam.
So it is marked there.
Properly demarcated, how much area is enclosed and how much is entitled, and what are the boundaries. It is specified in that. Exhibit 3.
Where is the discussion of exhibit 3 in the judgment?
There. Internal page 11
Of the
of
trial
the
judgment.
trial court.
Internal page 11.
Page 34 of the memo of appeal.
Yes, please start.
In the between. Say it 3549, exhibit 2, related to khata number 86, Thana 57, in the name of Pekun Thakur, area 25 decimal. The plaintiff has adduced the certified copy of the sale deed 3549, 16 December 1987, exhibit 2, and original sale deed 3549, exhibit 3 on behalf of defendant. The certified copy of the report of Karmachari that is produced by the plaintiff is the demarcation report, exhibit 3. The present document is the certified copy related to application given to the circuit officer Gamaria with respect to demarcation case number 09 and 10 oblique 1415. In the report of Alka Karmachari dated 24 December 2014, the land has been compared with the map khata number 86, Kesra number 645, total area 5 and 0.15 acres area 20 decimals situated at Mauza Chota Gamaria, Thana 67, khata 86, Kesra number 645 oblique, purchased on the basis of sale deed number 260 dated 3/2/2014, sale deed number 2270 dated 18 September 1962, during the demarcation in the northern corner 27 that has been demarcated in north side PCC road, east to west PCC road and north Samshan, and it also mentioned that the purchaser Puran Chand Mishra has purchased from whom the purchaser Srimati Ganga Rani Paul by sale deed number 3549, 16 December 67, total area 5 decimal, and in demarcation it was found upon that total area 7.5 decimal, the house has been constructed. They had purchased only 5 decimal and it was found that 7.5 decimal they had occupied. The report is attached with the trace map and certified copy. The plaintiff during course of evidence had adduced the original sale deed 2270 of 1962, Exhibit 4 and Exhibit A. Present deed is the bilateral document relying upon both the parties which is not in dispute. is also filed on behalf of the defendant as per the contents of the same deed. The same has been executed by Vaikunt Nath Kavi, son of late Vinayak Kavi, in favor of Puranjan Mishra of the land situated at Chota Kamaria. This is with regard to Exhibit 3.
So your contention is the land is well demarcated
Well demarcated.
by virtue of the report of the circle officer. So the suit land was not vague. Suit land was not vague.
Not vague. And it was also described in para 4 and 5.
बोलना है आपको और that should be sufficient.
Only one line. One line. What is suit land? It is mentioned, and that is reflected in the decree.
No.
Now the executing court would not make an inquiry, that it would not go and look into the circle officer's report or Anchal Amin's report to verify and to find out what is the suit property. Suit
No, but
property is the
executing
property.
court will certainly look at the judgment. Executing court is supposed to look at the judgment. And then while executing, it will find that Exhibit 3 has been mentioned.
That is the reason that particular direction was passed by the honorable. That was the reason. That it has to be done by the trial court itself, not by the executing court, not during the execution stage. All this should have been done during the trials itself. Now suit property, time and again suit property word has been used, and suit property would be executed. Suit property is only the property which is mentioned in the decree and the plaint itself. That is all. Which is clear, which is described as this is the suit property. It only mentioned 2.5 decimal, not mentioning as to.
And the suit property by itself is not referring to any demarcation.
Absolutely not. Now the executing court, then again in this case, then all other cases, Your Lordship, it would be that the executing court would now refer to the judgment to find out as to what is the suit property. That exercise is not permissible. Your Lordship, let us assume an impugned order comes up before Your Lordship, where the executing court, there is a decree which mentions the suit property, but the executing court interprets it, relies on the documents which were adduced by the parties, and then carves out a separate property or a property which is not mentioned in this decree. Would it be permissible?
This issue was not taken up by both the courts. No, none of the courts framed this issue.
No.
The appellate court, you were the appellant for the first appellate court.
Confident, yes.
No, the point of determination before the first appellate court was para number 16.
I was just checking whether actually there was an issue before the trial court or not.
Para number 16.
Para 15, no?
Para 16 of the appellate court.
Yes, the point for
And
determination
what is the corresponding issue of the learned trial court? What were the issues framed by the learned trial court?
Yes, yes. Issues are at internal page 7 of the trial.
Which issue is concerning this point?
No issue. No.
They have not even suggested this substantial question of law in their memo.
Still it can be changed.
Yes, sir.
So
Yes.
don't divert from the central issue. Where is the answer to issue number 11 by the learned trial?
Issue number 11 of the
Right.
it is consolidated in page 10 it starts. Internal page 10 para 7 and
You see page number 50.
page number
50. 50. Running page 50, internal page 27. This is the property which you were claiming by virtue of an agreement of sale.
by
That was
agreement
your
of sale.
case. That
Yes.
was your case.
It
You were
was
entitled to this property.
it was 2 decimal, whereas the allegations are that I have encroached 2.5 decimal. So, but this also, this description also is not there. The again, Your Lordship, the same question would arise whether this was there in the suit property, whether suit property is identifiable or not. That is the only question.
So in such circumstances where identity of the suit property is disputed and no issue has been framed by both the courts, so what is the remedy? The suit will fail for all times to come.
Honestly, it was not, but this could have been, they could have, both the trial court, appellate court and the plaintiff themselves. They were required to bring it by way of specific identification that this
What
is
is the remedy now?
the remedy that
We are at the second appellate stage. This is such an important issue which has not been framed. Whether on the basis of whatever be the material on record, it can, if the suit is found to be if the property is found to be identified, then under such circumstances the decree will still survive. In the first appellate stage also, in the second appellate, either we'll ask them to return a finding on this, or we will give a finding ourselves.
whatever Your Lordship deems.
No, what is the procedure of law? This is what I'm asking. You are such a
No,
senior advocate. I'm
because
asking
Your
you.
Lordship, my own
Your
understanding.
experience.
No,
with-
my own understanding is that Your Lordship, even as second appellate court, Your Lordship has all the powers under section 41, order 41. Because second appeal is there in section 100, read with, it has to be read with order 42. Order 42 very clearly mentions that apart from these, all the powers of order 41. So the second appellate court, although it is second appellate court, it has all the powers which is there in order 41. So order 41 it says, this is there that order 41 to 33 says.
May I forget?
You may see.
एक सेकंड सुनिए, आपको बिना सुने तो ऑर्डर नहीं
जी,
करेंगे.
जी.
You are confident about that? Order 41 rule.
First, Your Lordship may see order 42 itself.
Yes.
Appeals from appellate decrees. Order 42.
Yes.
So it says that the rules of order 41 shall apply so far as may be to the appeals from appellate decree. So same rule would also apply to the second appeals also. That means order 41. And then Your Lordship may see order 41 rule 33. Because this is the power of court of appeal. The appellate court shall have the power to pass any decree and make any order which ought to have been passed or made, and to pass or make such further or other decree as order as may require, and this power may be exercised by the court, notwithstanding that the appeal is only to a part only of the decree and may be exercised in favor of one or any of the respondent or parties, although such respondent or parties may not have filed any appeal or objection, and may there have been decrees in lawsuit also and so, or passed in one suit be exercised in respect of all or any of the decrees, although an appeal may not have been filed against it. The appellate decree shall not make any order under so and so. So, Your Lordship, all the powers are there with this.
So therefore, whatever materials are placed before this court, if this court finds that the suit property is identifiable otherwise, that decree can become.
Then Your Lordship has to modify the decree.
Yes, certainly. That has to
Modifying
be
the
because
decree and then.
the core of the issue before us is whether the property is identifiable.
Yes.
And if the records would reveal that the property was identifiable, then under such circumstances that decree will be modified, because that is the whole purpose
Yes.
of adjudication of such an issue.
Absolutely.
So for that we'll have to refer to the evidences on record. It cannot be simply said there are materials to which may indicate that the property could be identified. There are materials, because if the map which he is referring earmarks this area clearly, then under such circumstances we'll have to see what is the evidence cross-examination so far as this map is concerned. That will serve the purpose.
But then ultimately the decree has to be.
Yes, it will be modified. If it has to be modified, it has to be
Yes,
modified.
yes, it cannot be, now this cannot be left to the executive.
No, we will not leave it. Rightly so, we will not leave it to the executing court. We will find it out as to whether the property is otherwise identifiable from the records.
Otherwise it would be easier for defendant judgment debtors to easily leave these appeals and then to raise all these issues in
Certainly.
the execution stage.
Execution में तो आप शिक्षा लगा दीजिए. You still want to pursue it because that objection you can still raise at the stage of execution. नहीं तो जितना मटेरियल है आर पार का लड़ाई आप लड़ लीजिए सीधा सीधा.
हाँ, अगर आइडेंटिफाइबल है तब.
हाँ, नहीं भाई फिर आप अगर उसमें उस इशू पे आप घुसेंगे तो आप निकलने नहीं देंगे ना, फिर आप तो फाइंडिंग ही होगा.
निकलने का नहीं. मेरा evidence was only with regard to 2 decimals additional, whereas they say that I have encroached 2.5. So this also then
नहीं,
my
आपका जो वो अमीन का जो रिपोर्ट
हाँ वो
उसमें 2.5 है
हाँ
कि उसमें 2 है कि उसमें आपका अर्मार्क है, क्या लिखा हुआ है उसमें, अभी तो देखे नहीं है मैप उसका, और उस पर क्रॉस एग्जामिनेशन भी नहीं देखे। दूसरी बात जो एडिशनल चीजें बोल रहे हैं वो उस पर कुछ बिल्डिंग खड़ी हुई है, ठीक है, तो अदरवाइज भी प्रॉपर्टी काफी आइडेंटिफाइबल लग रहा है, मतलब बाहर से।
नहीं
वो भी कौन सा पोर्शन है?
वो नहीं, ये नहीं बोला जा रहा है कि ये 7.5 में बिल्डिंग बना हुआ है, ये बोला जा रहा है।
वो तो
ये नहीं बोला जा रहा है कि सिर्फ 2 डिसमिल में बना हुआ है।
नहीं, आप वो तो अमीन का रिपोर्ट ही देखने से पता चलेगा ना। If the property remains completely unidentifiable, even after perusal of the record, then this decree, being a non-executable decree in view of the judgments, has to go. इसका कोई उपाय नहीं मेरे पास। लेकिन if the property is otherwise found to be identifiable on the basis of material on record, then we will sustain the decree and indicate that which portion is to be evicted. That decree will be modified. Or else, even being a judgment debtor, you have a remedy under the provisions of law to raise objections at the stage of execution.
I have it, but
I don't know. सोच लीजिए दोनों में से क्या करना है।
सोच लेते हैं।
सोचिए, बात कर लीजिए। वहाँ पे ऑब्जेक्शन रेज करना है कि यहाँ पे आपको अथॉरिटेटिव डिसीजन चाहिए, क्योंकि डिसीजन यहाँ पे घुसेंगे तो फिर तो होगा ही ना।
हाँ वो है, वो हम
अगर हमको मिल जाएगा मटेरियल तो आपके खिलाफ चला जाएगा, नहीं मिलेगा तो इनके खिलाफ चला जाएगा। अभी तो कुछ भी फाइल नहीं खोले, सीरियल नंबर 55 का फाइल पढ़ के भी नहीं आए।
Your Lordship will continue here itself because I've been told that issue read for delivery of possession has been issued.
तो आप वैसे हम कहाँ बोल रहे हैं? वैसे हम तो आपको नहीं रोक रहे हैं। आपने 10:30 बजे मेंशन किया, 2:15 बजे आपका केस टेकअप हो गया, 1 घंटा 2:15 बजे नहीं, 2:30 बजे। अब आप मटेरियल दिखाइए, आप दिखाइए मटेरियल, ये तो आपका काम है ना कि प्रॉपर्टीज आइडेंटिफाई एग्जिबिट से दिखाइए और एविडेंस से दिखाइए।
My first submission is कि identification of property is a question of fact. There is concurrent. Secondly,
नहीं, देखिए आप इनकी बात,
अच्छा ठीक है मैं
डिक्री इनका बन गया।
हाँ।
अब ये बोल रहे हैं कि एग्जीक्यूशन किस प्रॉपर्टी पे होगा, बिकॉज द शेड्यूल इज वेरी वेग। उसमें ना कोई बाउंड्री है, ना उसमें कुछ है, उसमें ऐसे ही लिखा हुआ है कि 2.5 डेज।
My further submission is कि executing court can see the judgment to remove ambiguity. This liberty is before the executing court. For that, I can cite you.
ये वाला जो सुप्रीम कोर्ट में ये मैटर गया था, एग्जीक्यूशन से गया था कि टाइटल सूट से गया था?
Mainly related to executions.
है ना?
Yes. But then Your Lordship may see now what problems the execution case, the executing courts face is the reason for this. लेकिन हम एक बार देख ले रहे हैं क्या constitution.
It is all relating to execution, कि execution में problem नहीं होना चाहिए।
हाँ.
लेकिन अगर कोई ऑब्जेक्शन आपको एग्जीक्यूशन में लेना है that the suit property is otherwise not identifiable, then you will have to raise this objection at the stage of execution, not as a in a second appeal.
No, I'm not saying that, Your Lordship. Your Lordship, I had referred to that paragraph, Your Lordship may see, what the court says, that the court must before passing the decree. That is what the court is saying. That so that ultimately the
अच्छा छोड़िए, अब हम लोग प्रॉपर्टी को आइडेंटिफाई
हाँ,
करने
वो
का
ठीक।
कोशिश करते हैं। आप प्रॉपर्टी आइडेंटिफाई कराएंगे फ्रॉम द रिकॉर्ड्स? करवाइए।
Exhibit 3 is clear.
चलिए,
Shaded
exhibit
portion है.
Exhibit 3. प्लेस करिए Exhibit 3 प्लेस करिए.
अंचल अमीन की रिपोर्ट है, there is a map annexed with this report.
पढ़िए ना Exhibit 3 थोड़ा पढ़िए.
Can we continue tomorrow? हम अच्छा से हम लोग दोनों देखें. Better रहेगा instead of wasting your lordship's time. एकदम precisely will point
और
out.
देखिए ये एक बहुत इम्पोर्टेंट चीज़ है. एंड सुप्रीम कोर्ट से तो डायरेक्शन ऑलरेडी आ ही चुका है. उसको हम रेटिलेट करके हम लोग अपना सेकंड एपिलेट स्टेज में हम लोग क्या कर सकते हैं
ठीक.
इस पे भी, क्योंकि अगर मान लीजिए ये जो सुप्रीम कोर्ट का डायरेक्शन है कि डिग्री क्लियर होना चाहिए, ये होना चाहिए, so that power of the trial court based on materials on record we can also exercise.
Yes, yes,
इसमें तो कोई इशू ही नहीं है.
But your lordship, it cannot. My appeal must not be dismissed in the entirety without identifying.
नहीं,
saying
उसके
that
बिना नहीं होगा.
even
अगर मान
if-
लीजिए आइडेंटिफाइबल नहीं है तो आपकी डिग्री को फिर हमको सेट असाइड ही करना पड़ेगा.
हाँ वो otherwise your
If it is otherwise identifiable, there is no problem.
what is the decree, your lordship? This is the decree of the trial court. It only mentions the property which they have mentioned as
In
in
the,
schedule
no, we
A.
will modify
And
the
the
decree.
court cannot go beyond that. The executive court cannot go.
Certainly,
beyond that. That is the decree.
therefore, because of the reason that the executing court will not be in a position to execute this kind of a decree, the core issue would be as to whether the property was identifiable. If we find that the property was identifiable, second appeal after admission is a continuation of suit only.
Yes.
If the property is still identifiable on the basis of materials on record, then we will clarify it, modify the decree accordingly. Otherwise, we will say it's a non-executable decree.
First, now your lordship can the court. Another problem. Absolutely fairly, I am saying. Can the court modify the suit property without there being any modification in the original plan? Because the
No, because
judgment.
when we'll see the plaint, we'll see the plaint as a whole. Isn't it? We'll see the plaint as a whole, because in the plaint, they are referring to the property, they are referring to the Amin's report, they are referring that this property has been identified
So
by the
what
Amin.
was the difficulty in mentioning it in Schedule A, which is the suit property?
आपके पास नहीं आए थे ना ड्राफ्ट करवाने, इसलिए डिफिकल्टी है. ठीक है, इसीलिए difficulty. आपसे नहीं ड्राफ्ट करा.
सर से भी नहीं पूछा.
सर से तो नहीं पूछे होंगे, that I know. I think that course would be good enough.
Yes.
आप हमको बता दीजिए, एविडेंस आप देख लीजिए, रिकॉर्ड यहाँ पर है, आप देख लीजिए जो जो एविडेंस आपको प्लेस करना है. लेकिन आपके रिपोर्ट से प्राइम फेसी नहीं लग रहा है कि आइडेंटिफाई. आप देख लीजिए. ठीक है,
आज ही मिला है मेमो ऑफ अपील, हमको आज मिला.
आज हमको तो अभी तुरंत ही मिला है, आपको आज मिला है. एबीसी देख लीजिए, एक नजर इस रिपोर्ट पर. एग्जिबिट 3. वो मैंने मार्क करके खोल के ही दिया है.
जी जी, इसमें एक मैप भी तो होगी.
वही मैप है, उसके साथ ही लगा हुआ है. तीसरा पन्ना पर मिला.
जी
बताइए, इससे कुछ आपको पता चल रहा है? आपने एग्जीक्यूशन कोर्ट में ऑब्जेक्शन नहीं फाइल किया?
इतना लेट हो गया that I we don't want to withdraw at that stage, and then if something happens then
नहीं
entire blame would be on us.
बेचे थे सिर्फ आधा कट्ठा, नहीं आधा डिसमिल, एक 5 डिसमिल।
एक बात
कितना था सेल?
5 डेसिबल इन्होंने खरीदा
5 डिसमिल।
20 डेसिमल टोटल इनका था, उसमें 5 डेसिमल अकॉर्डिंग टू मी ये वाला मेरे हिसाब से तो क्लियर नहीं।
सूट देखिए, ट्रायल कोर्ट का जो जजमेंट है उसमें बोल रहा है दैट यू आर एंटाइटल्ड ओनली टू 5 डिसमिल ऑफ लैंड एज पर द डीड। एनी फर्दर प्रॉपर्टी बीइंग ऑक्युपाइड बाय यू, यू आर सपोज्ड टू यूज। तो अगर आपका एग्जीक्यूशन में आपका प्रॉपर्टी अर्मार्क हो जाती है, बात करते हैं
वही हम बार-बार इसलिए वो क्वेश्चन में आ रहे हैं
अर्मार्क नहीं
कि
होगा।
5 डिसमिल इधर है कैसे, हाउ वुड द एग्जीक्यूटिव कोर्ट डिसाइड, and without there being any clear pleading by
Execution court has got no jurisdiction to appoint an ameen.
no, it has to very clearly, it has the power to appoint an ameen only for the purpose of again identifying the suit property. And what is the suit property? That the ameen cannot go anything, or the executive court cannot go anything beyond the property which is mentioned in the schedule A. Here, your lordship, it may be a case, but there would be some other cases also where this would be cited as a judge, that this is the power of the executive court. Then
When
what
the
would happen?
judgment says that you are entitled to only the property which is covered by your sale deed, and remaining you have to evict, is that not sufficient to say that the judgment is clear on this?
No.
Then under such circumstances, can the executive court not appoint an ameen to identify and demarcate your property? Because it is absolutely an integral part of this judgment which says that you are entitled to only to the property which you have purchased.
Yes, absolutely.
So in order to identify the property which you have to evict.
So, your lordship, if I took this in my defense very specifically, it is not a case that I have not taken this as defense. I say that this property is vague. Then also the court does not even frame an issue. They do not correct their pleading. They do not describe the suit property, and they continue with the trial. And even the ameen's report I have seen, that does not say anything. Absolutely vague. It only says that 7.5 decimal को लाल रंग से रंग दिया। ये कैसे होगा? Where is 5? How would the court now carve out 5 decimal which I have purchased? It is only one page, Your Lordship may see the Amin's report. Probably Your Lordship has already read it.
ठीक है, हमको तो नहीं लगता एग्जीक्यूशन में कोई भी दिक्कत होने वाली है। कल आपको जो आर्गुमेंट और
ठीक।
आप भी हमको बताएंगे कि एग्जीक्यूटिव कोर्ट किस हद तक जजमेंट देख सकता है and whether it is within the power of the
Yes, ma'am.
executive
That
court
will
and whether it is within the power of the executive court. You see, it is fine. आप इसको ऐसे देखिए. There is a saying where there is a clear cut demarcated property, right? इसमें तो कोई doubt नहीं. Now there is an allegation that you have encroached, somebody has encroached more than what has been allowed. In order to execute, there are two ways to look at it. One is ये पोर्शन ज़्यादा है, अलग से अर्मार्क है. दूसरा है कि आपका पोर्शन ऑलरेडी अर्मार्क है, उसको छोड़ के बाकी खाली कर दो. ठीक है. तो आप हमको ये बताएंगे, क्योंकि जो एक्सेस पर है उसका तो डिमार्केशन अलग से नहीं बाउंड्री दिया हुआ है, ठीक है. लेकिन जो आपका प्रॉपर्टी है, जो मतलब जो प्रॉपर्टी सेल डीड से कवर्ड है, अगर वो स्पेसिफिकली डिमार्केटेड है, देन देयर कुड बी, मतलब इतना छोड़ के बाकी छोड़ देना है. ठीक है. यही किया है लर्नेड ट्रायल कोर्ट कि इनका जो प्रॉपर्टी सेल डीड में आता है उसको छोड़कर बाकी इविक्ट करना. और चूंकि आपके उसमें आया है 7.5 डिसमिल जो है वो उनके पोजीशन में है, तो आपका मार्क करके अपना 5 डिसमिल जो होगा वो रह जाएगा और बाकी दे देना. यही हमको समझ में आ रहा है.
जी.
एक और जजमेंट सुप्रीम कोर्ट से कराएंगे.
हम there are judgments what the executing court can do, but again this is the last time I'm maybe repeating that a thing which essentially is required to be done by the trial court in the original suit proceeding, that cannot be done by the executive. This is all.
Even if we observe this, we have to modify the decree to some extent.
Absolutely.
Even if we observe this,
Yes.
then also the decree is required to be modified. Decree may not be just referring to the schedule of the property. It may also refer to the sale deed by virtue of which you are in occupation of 5 dismal.
But ultimately it has to be shown as to what was the boundary of the encroached portion. Because that is the portion which they say that is over and above my 5 dismal. So
That तो अमीन में आया है 7.5 डिसमिल आपके occupation.
वो ठीक है, लेकिन फिर अगर 5 डिसमिल उसमें से कौन सा पोर्शन?
5 डिसमिल आपका प्रॉपर्टी डिमार्केटेड नहीं है क्या?
ये जो
And if required, can the Amin not, can the executing court not appoint an Amin for demarcation, so far as your land is concerned?
No, because he would be identifying and taking out only the suit property.
इसका कॉज ऑफ एक्शन ही था कि एक डिमार्केशन केस चला था, उसमें प्रॉपर्ली मेजरमेंट हुआ था, देन बिकॉज़ फाउंड दैट ही हैज इनक्रोच्ड 2.5 डिसमिल ऑफ लैंड, देन आफ्टर दिस सूट वाज फाइल्ड.
Your Lordship, why would we search for everything else except the suit property? The ultimate duty is to entire pleading and the trial is related to the suit property.
वो genuine नहीं लग रहा आपका case.
हाँ वो ठीक है, वो ठीक है.
इसीलिए
लेकिन that does not mean that Your Lordship my any portion of the land would be.
I will not say that, but आप हमको जजमेंट लेके आइए, एग्जीक्यूटिव कोर्ट क्या कर सकता है? आप लाए भी हैं कोई जजमेंट?
My junior has just left, another case has been called.
This case has been called out of turn at the request of the learned counsel for the appellant and the learned counsel for the respondent has also appeared to argue this case. The argument of the case has commenced. The learned counsel for the appellant has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2021 bracket 06 SCC 418 and has submitted that the suit property was vague and consequently the decree is also vague. He has further submitted that it has been held by the Honorable Supreme Court that all courts dealing with suits and execution proceedings shall mandatorily follow the guidelines mentioned in paragraph 42, and he has in particular referred to paragraph 42.5, wherein it has been held that the court must, before passing the decree pertaining to delivery or possession of the property, ensure that the decree is unambiguous so as not only contain clear description of the property but also having regard to the status of the property. The learned counsel has submitted that an objection in connection with description of the suit property being vague was taken in the written statement as well. But none of the courts have framed this issue, and ultimately the decree has been passed to give vacant possession of the suit property which is vague. The learned counsel for the respondents has submitted that the second appeal once admitted is a continuation of suit. This is the correct proposition. इसमें तो कोई doubt नहीं है. Is continuation of suit. He has submitted that the judgment has to be read. Second appeal once admitted. नहीं है, ऐसा नहीं है.
As per my understanding, I mean,
but
First
according
appeal is
to me-
continuation.
हमको लगता है कि ऐसा proposition आप कहीं पढ़े हैं.
first appeal के लिए है. First
First
appeal.
appeal तो invariably a continuation.
but after admission.
After admission. देख लीजिएगा, आप तो नहीं लिखाते आपकी तरफ से, कल आइएगा ना, आपके फेवर का ही बात लिखा दे. चलिए कोई बात. The learned counsel for the respondents has submitted that the judgment has to be read as a whole, and the Amin report and the filing of the suit was preceded by an Amin report, and in the Amin report it was clearly mentioned that the defendant was in possession of 7.5 decimal of land, and as per the sale deed of the defendant, they are entitled only to 5 decimal of land. He has submitted that once the area of once the entitlement of the defendant is clear, the defendant has to evict 2.5 decimal of land. And therefore, according to him, the decree is not an executable. The decree is an executable decree. यही तो है? He submits that the matter be posted tomorrow so that he may place judgments as to the extent the executing court can go into, as to how the executing court has to read the judgment. ठीक है, आप लेके आइए. आपको नहीं लग रहा है ये सारी चीजें एग्जीक्यूटिव कोर्ट में होना चाहिए? Had you filed an objection? ठीक है, आप क्वेश्चन ऑफ लॉ बना है तो आंसर तो करना ही है. Post tomorrow for further hearing.
At 2:15.
कल 2:15 के लिए कोई केस रखें?
To half an hour.
नहीं. जितना तेजी से आप सोचते हैं उतना तेजी से हम नहीं सोचते.
नहीं मतलब हम लोग
Slow,
को
slow,
स्पेसिफिक तो पॉइंट आउट कर.
देखिए हमारा जब कोई सेकेंड अपील Second appeal is the jurisdiction of the court, जहाँ पे पूरे स्टेट के लिए हम लोग लॉ डिजाइन करते हैं। यहाँ पे डिस्क्रिशन का कोई स्कोप नहीं है, ना ही इक्विटी का बहुत ज़्यादा स्कोप है। अगर हम बोल देंगे कि अगर लॉ ले डाउन कर देंगे merely because the description is vague of the suit property, nothing, the executive court cannot do anything. और अगर वो मेरा जजमेंट गलत हो जाए तो बहुत दिक्कत है।
Why to go into executing court's duty or anything? Why not to go into the trial court's duty to identify in terms of Order 6 Rule 4, in terms of the specific pleading of the parties and
हमको तो लगता है कि ऐसा जजमेंट है कि सेकेंड अपील वंस एडमिटेड इज अ कंटिन्यूएशन ऑफ सूट।
लेकिन Order 41 Rule 33
हाँ,
says
अपने
that
आप ही
the
the
court
court
has the power
has the
to do
power
justice.
to do
That
justice.
whether it
You
is
can exercise such
continuation or
power.
not, all the powers of the original court are there to do substantial justice. That is all. And your lordship wanted some note of mine. I have several notes. I'll compile and I'll give it to you.
आप हमको दें। क्योंकि limitation is a huge
नहीं, I
issue in
have-
all the cases.
Actually, I have separate folders for litigation and specific relief act and all those.
आप जो है एज एन अमाइकस हमको सारे केस के लिए
अच्छा,
दे
हम दे
दीजिए, क्योंकि सारे जजमेंट्स में कुछ ऐसा नहीं हो कि कुछ छूट जाए,
ठीक
क्योंकि
ठीक
लिमिटेशन इज कमिंग अप इन ऑल द केसेस।
ठीक है। तो then
चैलेंज नहीं करते हैं, फिर
Limitation
बोलते
में
हैं कि
मेरा
नहीं
only-
चैलेंज करने का जरूरत है, ये सब
ठीक।
थोड़ा सा दिक्कत
then
है।
I'll give on limitation section 31 of specific relief act and section 30.
बस
That is.
इतना में मेरा आई थिंक
ठीक, ठीक,
25% बोर्ड उसी में
ठीक,
खत्म हो
ठीक,
जाएगा।
ठीक, ठीक।
Item 5, second appeal 127 of 2019.
My senior is in lesson court number 3.
Then it comes to 49 settlement. डेट हम लोग सोच कर देंगे, मिल जाएगा आपको डेट।
Item 6, second appeal 62 of 2023, along that and so on.
But the second case was admitted, the second appeal 99. The last date notes were given as short notes of arguments also.
और फर्स्ट केस का क्या हुआ?
But first case भी admit हुआ है,
पहले admit हुआ है।
पहले admit हुआ है। लेकिन second case में अगर मेरे फेवर में आंसर हो गया तो फर्स्ट वाला को आंसर करने की जरूरत नहीं। Because
कहाँ है रेस्पोंडेंट? उनका तो जब तक 4-5 बार एक
आ गया,
जज तब तक नहीं होता है केस। आपका यही रेपुटेशन हम बना दिए। 5 बार, हाँ? अब आप सर्वव्यापी बन जाइए। हर जगह रहा करिए।
no, to take your my second appeal 99 first.
क्वेश्चन ऑफ लॉ पढ़िए।
Yes. But it is 19 to 2025. Whether the court becomes corpus officio after preparation of final decree and therefore registering an application filed by defendant number 16 in the year 2011 was itself beyond jurisdiction, and the entire proceeding thereafter is without jurisdiction and is liable to be set aside. Whether without setting aside the final decree dated 37/2010 by any higher court, a fresh final decree would have been prepared. These are questions of honor. But I have given a notes of argument if you want to take that.
तो सुने थे ना
हाँ सुने थे. Let me just give a brief facts. Now the partition suit was filed. That was 52 of 1970, in which a preliminary decree was passed, and in that preliminary decree, where the plaintiff along with defendant number 16 was given 8 anna share, and defendant 1 to 4 were given 8 anna share. So the plaintiff 1 to 7 along with defendant 16 8 anna, and defendant number 1 to 4 were given 8 anna share. This was the preliminary decree. This preliminary decree was never challenged. Not the in consonance with this preliminary decree, not a pre-trial commissioner was appointed. An objection was raised by defendant number 16 before the pre-trial commissioner. That is on the next page. That objection was rejected, against which they preferred a writ petition. And during pendency of the writ petition notes, writ petition was dismissed on 1/11/2007. That is at page 79 of the compilation. After this note, the pre-trial commissioner submitted his report 6/3/2008, page 80. Thereafter, notes against this pre-trial commissioner's report, they objected and their objection was rejected on 11/5/2009, against which they preferred a writ petition. That is WPC 3017 of 2009. During pendency of the writ petition notes, final decree was prepared on 26/2/2010. For 26/2/2010 notes, a final decree was prepared, allotting their share in terms of the pre-trial commissioner's report. Thereafter, notes, they withdrew that writ petition and they filed an
fresh objection.
they filed an appeal against that final decree.
Oh.
They filed an appeal.
An appeal was also withdrawn.
An appeal was also withdrawn. But the Lordship may kindly take notes the compilation, page number 120, where they have withdrawn the appeal.
Yes, 120.
120. But this is title appeal 31 of 2010. Attendants have been filed on behalf of the appellant as well as the respondent to their respective lawyer. Case called out. By way of filing a petition, it is submitted on behalf of the appellant that the appellant does not want to press this appeal or to proceed any further. As such, prayer for withdrawal of this appeal. Prayer is allowed. On the basis of the submission made on behalf of the appellant, this appeal is dismissed as withdrawn. So, note, they withdrew this appeal. After withdrawing this appeal, and in this appeal notes, they have taken all grounds. I will show that memo of appeal also.
We did not.
So, notes, once they withdraw that appeal, then very cleverly notes, they again moved before the pre-trial commissioner, the court below, and made an application for appointing a pre-trial commissioner for demarcation of their share, defendant number 16. So, note, the entire basis that once the final decree was prepared, an appeal was filed, appeal was withdrawn. Therefore, the court had no jurisdiction at all to entertain their application.
आप बताइए कैसे ऐसे किए हैं? Did आपका dismiss हो गया? आप अपना अपील withdraw कर लिए. उसके बाद ये दोबारा demarcation कैसे होगा? Demarcation तो final decree के पहले ही होता है ना?
Demarcation was order of the writ court.
As per the order of the writ court. कहाँ है वो writ court का order?
Court लगाया
नहीं वो नहीं लगाया. आप आपको exhibit दिखाइए. आप आपको ऐसे writ court का order मत दिखाइए. Exhibit दिखाइए. कौन सा exhibit?
exhibit नहीं.
फिर क्या?
Can see the first order.
First order means?
Was challenged by the civil appeal, in which it has been held that after order passed by the writ court.
कौन सा order? writ का writ का order.
105/2014.
That's why account should be one balance.
1053 of 2014. कहाँ है border?
Yes.
ये 5074 of 2007.
ये रहा आपका page 153 of the compilation. This is the case where the entire procedure has been given a go by the court. Because I am challenging not the initiation only in the year 2011. That is the application by defendant number 16.
भाई यहाँ पे तो रिट कोर्ट का डायरेक्शन है कि प्लीडर कमिश्नर अपॉइंट करके तख्ता बनाइए.
Huh, but therefore I say कि once the appeal was withdrawn and there again
Very
that
party in the writ proceedings.
yes, the writ petition was filed by me only. The writ petition was filed by me. Lord may kindly see.
आपका क्या cause of action था? ये 74 का सूट चल रहा है.
74 का सूट है.
आपका जन्म हो गया
1970
था?
का पार्टीशन सूट. Sorry.
90 आपका जन्म हो गया था
नहीं
70 में?
नहीं.
हाँ, what is this? कितना आप लोग परेशान करिएगा भाई? तो 70 का पार्टीशन सूट चल रहा. इसमें आप पार्टी थे.
Yes.
This all happened after the final decree, after
After the final decree.
everything.
Yes.
इसमें डायरेक्शन है प्लीडर कमिश्नर अपॉइंट
Lord, direction क्या है pleader commissioner appoint करने का? The lordship may see not because your lordship is with me on this at least. That was after dismissal of their appeal or withdrawal of their appeal. Any application by them for appointment of fresh pleader commissioner cannot be done.
इस डायरेक्शन का हम लोग क्या करें?
Huh?
ये तो डायरेक्शन
But
है.
I say
It is useless.
no.
आपके केस
But
में हुआ है ना?
after this direction, because I am challenging the proceeding initiated in the year 2011 itself. So if that application was not maintainable in law, any direction after that in the year 2014 writ petition,
रिट पिटीशन तो आपके फेवर में अलाउ हुआ था.
हाँ मेरे फेवर में हुआ नोट इसमें तो खाली यही बोलेंगे
इसमें प्लीडर कमिश्नर आप ही के कहने से
नोट क्या हुआ ये नया एक एप्लीकेशन दे दिए नया एप्लीकेशन पे प्लीडर कमिश्नर बहाल हो गए प्लीडर कमिश्नर बहाल हो गए अब नोट प्लीडर कमिश्नर के बहाल के बाद ये नोट पेज 6 पे दिखा है कंपाइलेशन लेट मी प्लेस दैट page 6 note here that the legal of original defendant number 16 namely Rajkishore Chaudhary very cleverly and plain fraud upon the court and without disclosing the fact that against the final decree dated 26/2/2010 title appeal number 31 of 2010 was filed by Rajkishore Chaudhary through his power of attorney holder namely Bhupnath Mehta and the said title appeal was withdrawn on 24/2011 filed a petition in partition suit number 52 of 70 dated 29/3/2011 in which a prayer was made to appoint a pleader commissioner for allotment of taktabandi of 4 anna share out of schedule A land for the purpose of separate final decree in favor of petitioner as per his taktabandi. That it is relevant to state that title appeal number 31 of 2010 was filed by Rajkishore Chaudhary through his power of attorney holder namely Bhupnath Mehta and withdrawal of title appeal on 24/2011 without disclosing the said fact about title appeal and its withdrawal Rajkishore Chaudhary through the same power of attorney, namely Bhupnath Mehta, had filed a petition on 29/3/2011 for the aforesaid relief as stated above. That from perusal of the petition dated 29/3/2011, it is apparent that Rajkishore Chaudhary and his power of attorney holder have suppressed the material fact deliberately and have tried to mislead the court and have approached the court with unclean hand. And on the opposite ground, only Rajkishore Chaudhary and his power of attorney holder have deliberately misled the court. Proper action have taken against so and so. Deliberately misleading the court and suppressing relevant fact and are trying to mislead. Now, notes after this, the pleader commissioner was appointed.
To allmark the share of defendant number 16 to 18.
No, only 16 because 17, 18 were deleted. Subsequently,
नहीं, आपने जो रिटन सबमिशन में लिखा हम तो उसी की बात कर रहे हैं।
हाँ, रिटन सबमिशन में हम लोग लिखे 26/2/2010 को फाइनल डिग्री बन गया।
नहीं,
सब्सिक्वेंट
आपने रिटन सबमिशन में लिखा है कि
Yes.
दिस ऑर्डर वाज रिलेटिंग टू और मार्किंग द ये पेज नंबर 9
यस
fixed for hearing for determining the legitimate share of defendant number 16 to 18.
16 to 18
यही है।
बट सब्सिक्वेंटली 17 और 18 का नाम डिलीट कर दिया गया which is also by the order और खाली डिफेंडेंट नंबर 16 ही रहा,
आप किसको रिप्रेजेंट करते हैं?
ओनली 16।
ओनली 16।
इन्हीं के एप्लीकेशन पे नोट फिर पूरा प्रोसीडिंग स्टार्ट हो गया।
नहीं तो फिर आप हमको बताइए ना रीट कोड को आप कैसे ओवरकम करेंगे?
रिट कोड को हम ऐसे ओवरकम करेंगे बिकॉज if the proceeding procedural law, these are proceedings, if the proceeding itself is bad in law, then any order passed on that,
You see every तो आपका क्या कहना है रीट कोड का ऑर्डर गलत
तो हम लोग ये कह रहे हैं कि रिट कोड का ऐसा कोई डायरेक्शन नहीं है। रिट कोड क्या
डायरेक्शन
बोले?
है
रिट
कैसे
कोड,
बोल रहे हैं?
हाँ रिट कोड क्या बोले?
पढ़िए
हाँ
कैसे बोल रहे हैं? The writ petition stands allowed in the aforesaid terms with a direction to the executing court to appoint a survey knowing pleader commissioner within 1 month for allocating separate taktas for the parties.
Yes.
हाँ तो
Now notes, this has to be read along
अब
with
तो डायरेक्शन नहीं
just एक पेज पहले पैराग्राफ 8 of onwards, para 8 page 155. Accordingly, the impugned order dated 17/2/2013 is modified to the extent that defendant number 16 is entitled for his share along with plaintiff in the suit property, suit schedule property. This was the decree. Therefore, the court modifies this. If defendant number 16,
आप हमको एक बात
Yes.
बताइए अगर मान लीजिए कोई प्रॉपर्टी 4 आदमी के बीच में डिवाइड हो जाती है
yes,
और उसके बाद पता चले कि एक और आदमी है जिसका शेयर और माफ करना है तो सारा ही फिर से होगा ना
not ये
वो 4 आदमी कैसे बोलेंगे इट हैज बिकम फाइनल
नहीं चार आदमी इग्नोर ये
जब
प्रॉपर्टी ये
और
किसी
बात-
थर्ड पार्टी आएगा तब नंबर ये तो शुरू से ही डिफेंडेंट है और इनके फेवर में भी डिक्री पास
इनके फेवर में कोई भी सूट प्रॉपर्टी कभी एलोकेट हुई ही नहीं
हुआ है।
नहीं सूट डिक्री में हुई होगी एग्जीक्यूटिंग कोर्ट ने डिफेंडेंट
नॉट
नंबर
प्लीडर
16
कमीशन का रिपोर्ट देखा जाए, हम प्लीडर कमीशन का रिपोर्ट लगाया है डिफेंडेंट
देखिए ऐसा है आप बड़े आराम से बोल सकते हैं कि इस ऑर्डर का कोई रेलेवेंस नहीं है या आप ही के केस में ऑर्डर हुआ है यू कैन नॉट शट योर आई कैन नॉट शट माय आईज टू दिस ऑर्डर हम तो ऐसा नहीं बोलेंगे कि कोई कोऑर्डिनेट बेंच ने आप और आप ही के केस में हुआ आप
हाँ,
उसको
मेरे ही
चैलेंज
केस में
करते
हुआ।
रिव्यू करते जो मर्जी करते आइए एक सीएमपी फाइल करके रीट पिटीशन विड्रॉ कर देते हाँ हो सकता है इसको जो है मॉडिफाई कर दीजिए जब when there is a direction of the court for appointment of leader commissioner that has to be followed it's simple सा बात है इसमें क्या है
नॉट लेट मी जस्ट then find out कि because this is a peculiar case यहाँ पे एक बार फाइनल डिग्री बन गया फिर एप्लीकेशन आ गया अपील विड्रॉ हो गया
कोई
उसके बाद
कहानी
फिर से
नहीं।
नया स्टार्ट
और क्या होगा रिस्पोंडेंट अगर मान लीजिए डिफेंडेंट नंबर 16 का फिर से अनमार्क हो ही जाएगा तो जमीन ही है ना
हाँ।
कोई उसमें से 1 इंच तो घटेगा बढ़ेगा नहीं
बट घटेगा बढ़ेगा नहीं लेकिन पेज 162 में लिखा जाना इसको ऑलरेडी मिल चुका है सबको अपना अपना शेयर एंड इनफैक्ट मैप भी प्रिपेयर हुआ अलग अलग शेयर भी सबको मिला क्योंकि अल्टीमेटली नॉट व्हाट इज द डिग्री इट इज प्लेंटिफ along with defendant number 16 8 आना शेयर your lordship may kindly take page 162 जहाँ पे pleader commissioner का रिपोर्ट
देखिए हम आपकी कोई बात नहीं सुनेंगे when there is a direction of the writ court in a case where inter party are fighting and when there is a direction that it has to be pleader commissioner has to be appointed and the share of the parties right खाली just for defendant number 16 का share नहीं share of the parties is to be redetermined तो क्या हम बोलेंगे
now if this is your lordship's view then I have to see and verify how can I overcome this writ court order page 153
तो आप वह जगिए कल सुबह साढ़े
नहीं,
10
कल तो
बजे
नहीं,
नहीं तो
कल।
अभी ऑर्डर करें
नहीं कल मत रखिए कल नॉट ऐसे भी दो दिन से
देखिए
यही
आपको
कर
था हम आपको सीधा बता दिए इस ऑर्डर को हम आंख नहीं बंद कर सकते
दो दिन से नोट यही ऐसे बाकी केसेस भी लगा हुआ है कल नहीं नेक्स्ट वीक पे कोई भी
3
डेट
दिन छुट्टी था
हम
तो क्या करें?
नोट अभी सुबह से तो वही वाला चल रहा था ये लॉटरी मशीन में 2-2 सेकंड अपील कर दिए।
और हमारे पास भी इतना सारा सेकंड अपील है, इसके बारे में कभी चिंता की है?
नहीं,
देखिए एक चीज बता दे रहे हैं, एक रिकॉर्ड को एक बार सुनने के बाद उसको एडजर्न करने से मेरे लिए काम बहुत बढ़ जाता है।
इसको 15 कर दिया।
नहीं 15 को नहीं, कल करना करिए, नहीं तो अभी ऑर्डर लिखो।
नोट्स
नहीं तो ऑन द फेस ऑफ दिस ये तो ऑर्डर आपने दिखाया ही नहीं।
हम तो हम अपने ही कंपाइलेशन बनाए हैं, इस पे हम अपने ही लगाए हैं।
ठीक है, अच्छी बात है।
एंड आई हैव डिस्क्लोज्ड एवरीथिंग।
आप कल आ जाइए, इसको जो करना है आप इस बारे में करिए, इसके बियॉन्ड कुछ नहीं।
बट तब कल नहीं, नहीं एक दिन का नहीं।
The learned counsel for the parties are present. The hearing in the civil appeal has commenced. The learned counsel for the appellant. The learned counsel for the respondent in second appeal number 99 of 2023 has submitted that the pleader commissioner was appointed by the executing court pursuant to order dated 22/11/2018 passed in WPC number 1052 of 2014 in writ petition which was filed by the appellants of second appeal number 99 of 2023, and therefore it is not open to the appellant to contend that the executing court had become functus officio. In order to examine the impact of the order passed in WPC number 1052 of 2014, the learned counsel for the appellant prays for adjournment, and at his request it is directed to be posted on 9th to be taken up at 10:30. और आपका भी एक सेकंड अपील करना सेम है।
मेरा भी एडमिट हुआ है।
आपका सब्सटेंशियल क्वेश्चन ऑफ लॉ किस पर है?
Redistribution of the share.
कितना शेयर मिलना चाहिए 1/4 और 1/8
आपके हिसाब से कितना मिलना चाहिए?
इनका शेयर उतना मेरा शेयर है 1/4 + 1/4 हाफ रहता है राइट प्रॉपर्टी
एक प्लेंटिव को
डिपेंडेंट है
16 के साथ 8 आना मिला 50% और 8 आना चला गया डिफेंडेंट को। तुम लोग
आपने आप फाइनल डिग्री के अगेंस्ट में आए हैं
हां
कि
इन्होंने
प्रीलिमिनरी
फाइल किया अगर फाइनल अपील फाइल किया that has been remanded to the direction to review the same term one IBM में फाइनल अपील अटेंड किया तो रीट होगा विड्रॉ करके पीछे आना एक और रीट होगा किसी को भी फाइल किया
एक और रिट है।
हां वो 235 to 19
वो कहाँ?
और मैं इन ऑर्डर बात 23 लो 22 में चैलेंज किया जब चैलेंज करना फाइल
रिट में
हां आखिर विड्रॉ करा कि दोनों में फाइल किया सिविल अपील ये नेक्स्ट का फाइनल डिग्री फाइल
आपने तो अब तक कोई नोट भी नहीं बनाया है और आपकी आधी बात हमको समझ में नहीं आती।
ये हम बना
तो ये आप हाथ में लेके ये क्या आप बता रहे हैं
के पास
और क्या बताना चाहते हैं?
ऐसा रिकॉर्ड इनके दिमाग में भी है नॉलेज
दोनों के रिकॉर्ड दोनों के नॉलेज में है, लेकिन मेरे पास तो नहीं है ना। आप अपना नोट लेके आइए। ठीक है? The learned counsel for the respondent Mr. Virendra Kumar has also submitted that he shall prepare a short note of arguments and file it by 5 o'clock in the evening tomorrow. या 5 बजे तक आप जमा करेंगे। ठीक है? जो भी लगाना है उनको कॉपी सर्व करके ऐसे लुक्का छिपी नहीं करना।
कॉपी नहीं दिया कॉपी वो दिए
हमने वो रिटर्न सबमिशन तो कॉपी उसी दिन दिए सर, हम फिर दे देंगे आपको।
खाली वाली मेमो दिया सोनी में
क्या चीज़? हाँ?
खाली सगला मेमो दिया ये नहीं दिया पैसे नहीं दिया इनके द्वारा चला
देखिए जहाँ तक मेरा एक्सपीरियंस है कि ऐसा कुछ झूठ बोलते नहीं हैं हम। I've never
नहीं,
seen
हम
you speaking.
ये हम फिर देखो अभी तुरंत
और दूसरा एक्सपीरियंस ये है कि आपका फाइल सब ठीक से रहता नहीं।
फाइल कम नहीं मिला है, फाइल कम
हम देखते हैं आपका ऑफिस का फाइल सब आप ठीक से नहीं रखते, इधर उधर घुमाते रहते हैं। दे दीजिए भाई।
हम अभी
Orders के basis.
Orders will effect item 13, 1st April 318 of 2023.
उसके मेटालिक से आई नंबर 1255 2025
What is it for? इसलिए है
इसमें डिफेक्ट हम रिमूव नहीं किए हैं।
ignoring certain defect.
नहीं इसमें है कि जजमेंट एंड डिक्री में भी सेंड और लेट मी कोड रिव्यू फॉर नेसेसरी करेक्शन नोट्स।
Defect number कौन सा है?
Defect number 4. Address of the respondent number 2, Roman 4, which PO and PS is missing in CC of judgment and decree. Both may be sent to the
देखिए आइए number 1255 of 2025. The learned counsel for the appellant has submitted that this interlocutory application has been filed in connection with defect number
Defect number 4.
number 4 as pointed out by the office. He submits that the judgment and decree of both the courts be sent for correction. Office is directed to send the judgment and decree of both the courts for correction. The office should also indicate the rectification which is required to be made by both the courts while sending the judgment.
Lord.
आधा काम करके आ जाता है ना कभी कभी।
हाँ।
Are you disposed of?
Lord.
और भी कोई डिफेक्ट?
नहीं और एक तो डिफेक्ट ऑफिस नोट्स में भी आया all defects have been removed except the defect number 4.
आपने आइए 1225 किया ना, आपने एक्सटेंशन ऑफ टाइम पीरियड किया।
हमने प्रेयर यहाँ दिया हुआ है।
ऑफिस नोट में लिखा हुआ एक्सटेंशन ऑफ टाइम।
हमने यहाँ प्रेयर दिए हैं which will further pray to send down the judgment and decree to the learned to the court of civil judge senior division 3 at the Jharkhand for necessary correction.
डेट दे दीजिए। ये आएगा अब आपका मई में।
जी।
Ocean 7th May.
Orders item 14, 2nd April 454 of 2016.
This is the withdrawal application of second appeal for 2026.
You want to withdraw the second appeal?
Withdraw?
They want to withdraw this application.
आपको कोई objection? कोई खास कारण है अपना withdraw का?
The entire property has been purchased by us. We have already been party by the order of this court. By order dated 6/5/2024. The settlement has been arrived. They are withdrawn.
IA number 3730 of 25 and secondary number 454 of 2016. The General Counsel for the appellant has submitted that. आप नाम बताइए अपना?
Satyanarayan.
Mr. Satyanarayan Kumar Advocate on instructions of Mr. Shekhar Prasad Sinha has submitted that the interlocutory application has been filed for withdrawal of the second appeal. Counsel for the respondents has no objection for the prayer for withdrawal. Accordingly, this second appeal is dismissed as withdrawn.
Item 15, 2nd April 579 of 2017.
This respondent notices were issued to respondents and respondent number 1 is applicant. And respondent and notice has been served to respondent number 2 to 4, but they haven't appeared as yet in the edition. And respondent number 5 is not, we are not able to find in the edition. Notice was issued twice. So fresh notice will be issued immediately.
Not found है ना, आप substituted service of notice लीजिए. ऐसे number 579 of 2017.
It may be served through police station because
Not found लिखा है तो कहाँ से पुलिस स्टेशन में वो खोज के निकालेगा? Does not reside at the given address.
and this is the address where you should be
तो आपको पेपर पब्लिकेशन सब्स्टिट्यूटेड सर्विस ऑफ नोटिस के लिए आपको करना पड़ेगा. क्योंकि 2 अप्रैल 579 of 2017. Let counsel for the applicant place for and is granted 2 weeks time to file appropriate petition with regard to substituted service of notice upon respond number 5 or to furnish the present and correct address of respond number 5 before this court. Post on 30th June. Stay है आपको?
limitation.
अच्छा अभी आपका substantial question of law भी नहीं बना है ना? अच्छा.
Notice was issued on point of limitation.
2017 से चल रहा है. कितना साल हो गया? How many years? गिनिए. 8 साल से point of law भी नहीं formulate है. ये भी क्यों हुआ था?
Due to non-service of notice to respondent number 5, it is not.
कुछ नहीं है, पेपर पब्लिकेशन करा के अपने केस को.
Item 16, second appeal 81 of 2020.
Judicial in this case, respondent number 16 received notice through his wife, and respondent number 11 has died in this case, Your Judicial, and respondent number 15 could not be appointed, Your Judicial. So I pray for 4 weeks time to file substitution petition for respondent number 11.
और respond number 15 का क्या करें? Addressee could not be located.
This is the address we have derived from the record, and this is the address we have derived.
Speed post का आया है कि respondent number 1 to 16 has been received. कैसे आया? देखिए, AC number 81 of 2021. As per office note, the notice upon respondent number 16 has been received by his wife. Counsel for the appellant has submitted that notice be accepted as validly served. Considering the submissions, notice upon respondent number 16 is taken as validly served. Respondent number 11 has expired. And respondent number 15 could not be placed out. Counsel for the appellant prays for time to take appropriate steps in connection with respondent number 11 and 15.
15 may be sent through police station, otherwise they are avoiding.
Are you sure?
Yes, I have been instructed by the client. If 15 is avoiding the address.
15 का फिर से 16 का accepted as valid, 11 dead हो गया है तो इनका आप कर देंगे substitution कर देंगे. So far as respondent number 15 is concerned, the learned counsel for the appellant has submitted that he is avoiding service of notice, although he is residing at the address which has been given in the memo of appeal. कहाँ का रहने वाले हैं?
देवीपाड़ा धनबाद, हीरापुर धनबाद, टाउन में.
Office is let notice be issued to respondent number 15 through the concerned police station, for which requisite be filed before this court within a period of 1 week. the officer in charge of the concerned police station shall by serving notice upon respondent number 15 shall take self-attested copy of the Aadhaar of respondent number 15. And notice be served in presence of 2 witnesses. Pose this case on 10th of June awaiting service.
Item 13, second appeal 90 of 2022.
Yes.
The petition by order dated 21/25, notices were issued to the respondents, and according to the office report, the respondents have received the notice except respondent number 86 stating that nobody knows them. So a fresh notice may be served.
Respondent number 86. How many respondents are there?
And your lordship, respondent number 1C and respondent number 74 have died. So we'll be taking instruction from the petitioner and file the substitution petition.
ये तो आपको नहीं लगता है कि मेरे या आपके लाइफ टाइम में डिसाइड होगा ये केस? Is it a partition suit? Partition suit में किसी को भी उसको खुद ही सर्व होना चाहिए. किसी भी रिलेटिव को सर्व होने से पार्टीशन सूट में नोटिस एक्सेप्ट नहीं कर सकते. भाई को भी सर्व होने से नहीं कर सकते. तो दे आर कंटेस्टिंग. किसका किसका डेथ हो गया?
Respondent number 1C and respondent number 74.
Substitution of fine.
That's all a substitution already pending.
But the highest of the respondents, 31, 32 and 50 have received service.
Essay number 90 of 2022. The learned counsel for the applicant has submitted that. Respondent number 1 bracket C and 74 have expired. Please for 4 weeks time to take appropriate steps. Post on 12th of June. ठीक से देख के रिकॉर्ड बताइएगा, तब अगला डेट में एक्सेप्टेंस ऑफ सर्विस ऑफ नोटिस करेंगे. ऐसे करिएगा तो आपका ये केस कभी डिसाइड नहीं होगा. किसका एक्सेप्ट करना है, किसका नहीं करना है, दिस सबमिशन शुड कम फ्रॉम योर एंड.
Item 18, second appeal 153 of 2022.
Notice were issued after receiving PCS of notice. Respondent number 1 is aged as well as 9-10 और 13 का एटलीस्ट नहीं पता चला था. 10 जो भंडारा में नहीं है, वो जो फ्रेश सर्विस और नोटिस हम करते हैं. Is it correct address?
9, 10 and 13.
9, 10 and 13. And the address may be given by my debit fed also. I shall
9, 10, 13 का करेक्ट एड्रेस आप बता देंगे? कहाँ से बता देंगे? आप उनसे बात करिए, पता करिए. नहीं तो पेपर पब्लिकेशन कराइएगा टाइम्स ऑफ
ठीक है जी. और इसमें एक चीज और है, जितने भी रिस्पोंडेंट का हुआ है सब लोग या तो अपने किए हैं, कुछ लोग कुछ रिलेटिव किए हैं, या पार्टीशन सूट से.
पार्टीशन सूट में रिलेटिव को सर्विस नहीं मानी.
यस पेपर पब्लिकेशन इज एब्सोल्यूट.
पेपर पब्लिकेशन नहीं, आप दस्ती सर्व करिए.
ठीक है, दस्ती कर देंगे.
कितने सारे लोग हैं?
25 लोग हैं.
कहाँ के हैं सब?
सब मैक्सिमम लोग झारखंड के कुट्टी के कामडारा के. एक लोग पता चला कि आसाम में रहते हैं.
आप ऐसे इसको देखिएगा, ऐसे नहीं होगा. हो सकता है किसी का कॉमन इंटरेस्ट, वो आपको देखना पड़ेगा. आप जिसके ऊपर फ्रेश नोटिस करना चाहते हैं, जो करना चाहते हैं, यू शुड be very, very clear, there are so many respondents over here. अभी आप 9, 10 and 13 में fresh essay number 153 of 2022. Counsel for the appellant submits that respondent number 1 has already appeared. He prays for 4 weeks time to take steps for service of notice upon respondent number 9, 10 and 13 at their present and correct address. Through ordinary process. Admitted है second appeal
नहीं एडमिटेड नहीं है। इसमें दो सब्स्टिट्यूशन भी था।
लिमिटेशन का पॉइंट पे इग्नोर उसको
दो
मेमो ऑफ अपील सर कॉपी नहीं मिला मेरे
आप लोग अपना कॉपी लेते रहिए। Post this case on 12th of June.
इसमें दो आगे का सब्स्टिट्यूशन करना है।
ये आप लोग खुद ही तैयार नहीं करते। कौन नोटिस लिया है, किसको सर्व हुआ है।
सब ऐसे नोट किया।
इसको आपको देखना पड़ेगा ना किसका सर्विस हम एक्सेप्ट कर सकते हैं वैलिड। बाप बेटा का कर देंगे, ठीक है, भाई का नहीं करेंगे। और बाप बेटा अगर कॉन्फ्लिक्ट में है तो नहीं करेंगे। ये सब कौन बताएगा? तो फिर आप ठीक से देख के बताइएगा तभी प्रोसीड करेगा, नहीं तो उसके बाद लोग मरते चले जाएंगे और ये केस कभी डिसाइड नहीं होगा। सब्स्टिट्यूशन करते रहिएगा 50 साल में। दिख ही रहा है, एज भी 70 साल 80 साल सबका दिख रहा है। और भी कोई केस कॉल करिए जब बैठे।
Item 19, second appeal 48 of 2023.
Yes, Your Lordship, there's an IA for limitation. Notices were issued on the last day.
IA for limitation.
Yes, Your Lordship.
They have appeared.
No, Your Lordship. So, since the defendants of that doesn't serve on the Lordship.
How much is the delay?
88 days.
आज ऑर्डर नहीं करेंगे 4:30 बजे। essay number 48 of 2023. Counsel for the appellant has submitted that notice upon the sole respondent.
Sole respondent.
Who is the sole respondent?
ICICI Lombard General Insurance Company.
Sole respondent has been served through the manager. Considering the office note, the service of notice upon sole respondent is accepted as valid. Post this case under the heading for orders on next Tuesday for passing appropriate order on petition for condemnation.
Item 20, first appeal 138 of 2023.
I number 126/11/2024 for substituted service law. Application number 3 and 4.
IA number 12611 of 2024, the counsel for the applicant submits that his interlocutory application has been filed for substituted service of notice upon respondent number 3 and 4 by publication in daily newspaper.
Times of India, Kolkata
He
edition.
submits that Times of India Kolkata edition would be the one, could be an appropriate newspaper as respondent number 3 and 4 were residing in. And the last known address of respondent number
Yes.
3 and 4 is West Bengal. Considering the submissions, let notice be served upon respondent number 3 and 4 to substituted notice of newspaper publication in newspaper Times of India Kolkata edition and Telegraph. Both
Yeah,
of
those
these.
Times of India.
आपके लिखने से नहीं होगा। Telegraph is more popular
ठीक.
and Telegraph.
Kolkata edition.
Kolkata edition. The notice we prepared by the office.
हम ड्राफ्ट जमा करेंगे
Okay, the
within 2
draft
weeks.
notice we prepared by the applicant within a period of 2 weeks, and the same be handed over, the same be verified by the office and handed over to the learned counsel for the applicant for required publication. The matter is directed to be posted on 10th of July. 10th of July. Affidavit annexing copy, annexing
The extract of the copy.
extracting, annexing the newspapers be filed by 4th of July.
This I may be disposed.
I is disposed of.
Item 21, second appeal 244 of 2023.
In this case will be as per office notices which was sent. Respondent 1, 3 and 4 they have received by themselves. Respondent number 2 has received through his brother. Respondent number 3 already appeared.
So, what do you want?
So everybody, lordship has to accept the notice to be valid. 1, 3 and 4.
By themselves received respondent 2 by brother.
Respondent number 3 already appeared.
कोई रिस्पॉन्ड नंबर इसका ब्रदर से कोई कॉन्फ्लिक्ट तो नहीं है, क्या केस है ये?
ये कैसे स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट
Specific. SA 244 of 2023. Counsel for the applicant has submitted that respondent number 1, 3 and 4. The notice upon respondent number 1, 3 and 4 has been served. So far as respondent number 2 is concerned, it has been received by his brother. Respondent number 3 has already appeared. He submits that the notice be accepted as validity served. Considering the submissions, the notice upon the respondents is accepted as valid. Record आ गया इसका? The records have already been received from the concerned court. The matter relates to specific performance of contract. कब करना है? आपका सूट डिसमिस हो गया?
हाँ
आप प्लेंटिफ हैं?
डिफेंडेंट एपेरेंट है उनका
उनका सूट अलाउ हुआ होगा ना?
लाभ है तभी हम
तो
चले
एग्जीक्यूशन नहीं हो रहा है? आपको जुलाई में चाहिए, एग्जीक्यूशन नहीं हो रहा है?
एग्जीक्यूशन के सर 171/2018
तो एग्जीक्यूट हो जाएगा तो कितना दिक्कत? नहीं, इतना लंबा टाइम क्यों चाहिए?
जून में कर
Pose this case on 10th of June for final disposal.
11, 10 और
11 तारीख.
Item 22, second appeal 274 of 2023.
this case note there are two applications. One IA number 12612 of 2024. Another note for, that is for condonation of 99 days delay notices were issued. Now another IA note 12583 by 2024 for substitution of the appellant is within time. I have mentioned paragraph 3 of my petition in names of
वकालतनामा
Wakalatnama has also been filed.
लगता तो है कि फाइल होगी.
हुआ है जी
देखिए आइए नंबर 12583 of 2024. The learned counsel for the appellant has submitted that the sole appellant has expired on
on 15th February 2024,
15th
paragraph 4.
February 2024, and therefore the petition has been filed for substitution. The details of the legal years have
Paragraph
been
4.
mentioned in paragraph 4 of the interlocutory application. He has also submitted that the wakalatnama on behalf of the legal years has been annexed along with the interlocutory application. Any objection? The learned counsel for the respondents has no objection so far as the prayer for substitution is concerned. considering the facts and circumstances, IA number 12583 of 2024 is allowed. Counsel for the appellant is directed to carry out necessary amendments in the cause title in writing within a period of 15 days from today.
Lordship, I understand also that substitution petition, a copy of substitution petition be pending served to.
हम दे देंगे हम दे देंगे
और कुछ है बाकी
एक
लोग
IA is for condonation of delay of 99 days. That is IA number
all
1.
of them have appeared.
So notices were issued, not
तो
all of them have appeared.
आपको डिले में दिक्कत है? आपको कौन सिखाया है? मिस्टर सानी सिखा दिए नो?
हम तो जानते भी नहीं थे कि आज हमारे आधार साइट से
इनके चक्कर में मत पड़िएगा, आपको सिखा देंगे, बोल देंगे नो ऑब्जेक्शन। 99 days
जी
बताइए क्या चीज के लिए?
that I have explained in paragraph 3 and 4. Paragraph 4, 5. In fact, not the judgment was as pointed out this.
ये आप सेटिंग असाइड अमेंडमेंट क्यों फाइल किए हैं? ये तो विद इन टाइम है।
Within time, limitation.
अ-
This is not 97. She was the appellant was 97 years old. Paragraph
आइए
5.
नंबर बताइए।
IA number 12612 of 2024. 12612 of 2024.
देखिए IA number 12612 of 2024, this petition has been filed for condonation of delay of 99 days. The learned counsel for the appellant
Paragraph
Has-
5 and 6.
referred to paragraph 5 and 6 of the interlocutory application by submitting that the original appellant was an old age lady of 97 years. Counsel for the respondents has no serious objection with regard to condonation of delay. Accordingly, the petition seeking condonation being satisfied with the content, the petition seeking condonation of delay is hereby allowed. और एक कोई आइडिया है इसमें? सेटिंग असाइड अमेंडमेंट किस लिए फाइल किया?
इसलिए सब्स्टिट्यूट ऑफिस बोल दिया कि डिले हुआ है
किसमें डिले?
और सब्स्टिट्यूशन का
अपीलेंट का।
appellant. Receipt may also dispose it of 13470. That is
15 to 24 को है। आपने कब फाइल किया है सब्स्टिट्यूशन? कब फाइल किया?
16 February, so obviously it was
16।
16.
इसको सेटिंग असाइड अमेंडमेंट भी अलाउ कर देंगे, ठीक है?
IA में भी dispose.
दिस IA नंबर 13470
470.
जो है सब्स्टिट्यूशन के साथ IA नंबर 12583 ऑफ 24 दोनों को अलाउ करते हैं। डेट इसका
Date
18 to so हो गया सर? बचा है? देखिए सीनियर लोग बैठे हुए हैं जैसे ऐसे नहीं पूछते हैं। चलिए चलिए कॉल करिए।
Item 23 first April 9 of 2024.
हाँ बोलिए सर।
Notices were served to grandson or son.
बहुत लोग मर भी गए हैं, पहले उनको आप देखिए क्या करना है।
एक तो दो मर गए हैं उनका तो
2 भी मर गए हैं, 10 भी मर गए
10.
हैं। FA number 9 of 2024, counsel for the appellant as per the office note, respondent number 2 and 10 have expired.
10 2 का तो सब्स्टिट्यूशन कर दिया उसका नोटिस भी हो गया.
अच्छा 10 का
10 का ऑर्डर हो गए तो 10 का नहीं किया इसको.
as per office note, respondent number 10 has expired. Counsel for the appellant pays for adjournment to take appropriate steps. Post on 10th June.
Item 24 first April 131 of 2024.
The 10th.
Notices will be issued to the respondent notice. Office has pointed out that notice of the respondent number 11 and 12 received by son-in-law
son-in-law के साथ तो दिक्कत है बोलिए
and notice of respondent number 10, 11, 10, 11 to 15 not found at given address.
10, 13 to 15
13 to 15. I may be permitted to place states
FA number 131
correct address.
of 2024. Learned counsel for the applicant prays for and is granted
3
4 weeks time to take fresh steps for service of notice upon respondent number 10 to 15 at the present and correct address. Through order for which requisites be filed. In ordinary
Notice of the
process.
respondent number 11 and 12
11 and 12 का क्या था?
received by son-in-law.
नहीं मानेंगे
They
ना?
all were co-defendants with him.
नहीं कैसे मानेंगे? नहीं मान सकते।
इसका रिफ्रेश कर देते हैं 10 and 11
हाँ साहब हम तो 10 to 15 करते
10 to
हैं।
15.
But actual contesting, we are the only one. They are all defendants. Yeah. Few of the defendants have challenged him.
तो प्रोफॉर्मा है क्या?
हाँ,
तो एक्सेप्ट कर ले सन इन लॉ वाला। बोलिए
Son-in-law,
मुश्किल है ना?
एक ही है adult member of the family.
सन इन लॉ अभी फैमिली का पार्ट इंडिया में नहीं बना है।
Only,
अभी सन इन लॉ इंडिया में फैमिली का पार्ट नहीं है।
the matter would be prolonged, therefore I.
दस्ती ले लीजिए।
नहीं हम इसी में कर देते हैं अगर अगली बार नहीं होगा तो सब्स्टिट्यूट
दस्ती in addition. Dusty in addition. The affidavit of service be filed by 10th of June. दस्ती भी करके लेके आए। The co-defendants को। डेट हमका 18 जून।
18
Item 25, First Appeal 157 of 2024.
Notice by JSO and respondent number 1. Because only respondent number 8 and 12. Because are not appearing because but they have received notice. Respondent number 8 has received notice through sister-in-law and 12 has received notice personally. But rest all the belows because the main contesting is the respondent number.
Respondent number 12 has received personally.
So far,
5 to 12.
because so far respondent number 1 is concerned, I have filed
हाँ ठीक है।
other respondents I am filing it.
Respondent number 5 आप फाइल कर रहे हैं?
Fine, but except notes 8, respondent number 8 and 12.
8 and 12. Okay. 5 to 12 insufficient address. 5 to 12 insufficient address.
Notes 5 का हम
वो तो आप कर देंगे 8 and 12 का देख लेते हैं।
yes 8 and
8 received by sister-in-law.
yes.
कोई conflict है?
Partition can be accepted.
नहीं चलेगा partition suit.
Concession
देखिए FA number 157 of 2024. Counsel for the appellant prays for and is granted 2 weeks time to take fresh steps for service of notice upon responding number 8 and 12. Mr. Rajesh Krishna.
Where has received to be personally?
नहीं नहीं ऐसा नहीं दिख रहा।
हमको मेरे नोट शीट में सर
हाँ नहीं ऐसा तो
Ma'am,
पता नहीं
serious-
पहले का कहीं होगा तो आई गेस नॉट नो नहीं नहीं ठीक है he undertakes to file वकालत he has already appeared on behalf of respondent number 1 he undertakes to file वकालतनामा on behalf of the remaining respondents
except notes segregated.
except 18 तो post on 11th June आप अपना रिक्विजिट फाइल कर दीजिए विदिन 1 वीक within a week resident collected list ordinary process चल ओके अभी बाकी है दो केस बाकी कॉल कर
Item 26, First Appeal 3 of 2025.
Personally also he concerned with me.
दस्ती in addition कर रहे हाँ बताइए आप किस लिए हैं Yes.
This was issued. 18 of the respondents could not be served. 75, 93 total respondents were there. 18 could not have been served.
18
Yes.
कौन कौन से
75,
नंबर
Respondent number 30, 31, 66, 86, 88, 89, 90 and 91 have refused to accept.
ये क्या मैटर है? ग्रैंडसन, ग्रैंडडॉटर, पार्टीशन सूट है। पार्टीशन सूट में है तो रिश्तेदारों को सर्विस हम लोग नहीं माने।
I am representing 1 and 2. Respondent 1 and 2.
By their son, by their nephew. पार्टीशन सूट में आप अपना दस्ते ले लीजिए। दस्ते।
Majority have been received personally or by brother.
बताइए मेजॉरिटी में क्या लिखे हैं ऑर्डर में? Who has been served personally? Tell us.
1, 24, 48, 60, 70, 71 and 77 have been served personally.
कुछ तो नॉट फाउंड भी हैं, रिफ्यूज्ड भी हैं। As per the office note, respondent number 30, 31, 66, 86, 88 to 91 refused to accept notice. Considering the office note, the notice upon them is accepted as valid. The office note further revealed that respondent number 3, 4, 9 to 13, 27 and 84 were not found. Counsel for the appellant prays for and is granted 4 weeks' time to take fresh steps upon their aforesaid respondents at their present and correct address through orderly process. With respect to respondent number 93, as per office note, he could not be traced as his father's address has not been mentioned in the notice. Counsel for the appellant is directed to take fresh steps upon service of notice upon respondent number 93. Father's name नहीं पता है तो कहाँ से सर्व होगा? ट्रायल कोर्ट में भी इनका डिटेल नहीं था। Upon respondent number 93, through the concerned police station, for which the requisite be filed within a period of 4 weeks from today. और बताइए, sister, granddaughter ये सब नहीं मानेंगे। Grandson, mother, I do not know. इसके लिए हम लोग बाद में ऑर्डर पास करेंगे। Respondent number 1, 24, 48, 60, 70, 71 and 77 have been served personally. Notice is accepted as valid. Validly served.
And I am appearing for 1 and 2.
Respondent number 1 and 2 is appearing, has already entered appearance through wakalatnama. So far as other respondents are concerned, they appear to have been served. Their notice has been received through their by their relative, but appropriate order in connection with acceptance of notice will be passed on the next date, depending upon whether they have any conflict of interest with the applicant. Counsel to but depending upon if they have any conflict of interest with the applicant. देख लीजिएगा। Post on 10th of July, awaiting service report.
Item 27, first April 31 of 2025.
हाँ बताइए।
I have been invited for the information of delay in lordship. First time for
April number 31 of 2025 with IA number
2285.
2285 of 2025. Let notice be issued to the respondents. To all the respondents for which requisite under ordinary process, requisite under ordinary process with respect to respond number 1, 2, 3 and 6, and requisite under speed post with respect to respond number 4 and 5 be filed by the applicant within a period of 15 days from today. और तो कोई डिफेक्ट नहीं है?
No.
In the IE also, in the IE as well as the main appeal. ठीक है? Let the records be called for from the concerned court.
May I
This
submit
order
one
be
thing, Your Lordship?
communicated
On the
through.
first page of IA, Your Lordship, there PA has been wrongly mentioned.
आपको उसके लिए IE फाइल करना पड़ेगा उसके लिए कुछ.
बाकी ये correct है, Your Lordship.
हाँ?
सब जगह correct लिखा हुआ, एक पेज में केवल 226 या 235 लिखा है. बाकी जगह correct है.
The learned counsel for the applicant has also submitted that
In the first
in
page
the
of IA.
first page of interlocutory application, the number of days for delay has been mentioned, has been inadvertently mentioned as 235 days instead of
226 days.
226 days. And in the prayer portion, the correct figure has been mentioned. He prays for and is permitted to make necessary correction in the interlocutory application, and at time of issuance of notice, the corrected copy of the interlocutory application be released. Date it today, दो हफ्ता टाइम दिए ना 18 जून